This is TLV1.
The Tel Aviv Review.
Hello and welcome to the Tel Aviv Review, a program dedicated to books and ideas as well as many other things, brought to you by the Van Leer Jerusalem Institute, which promotes humanistic, democratic and liberal values in the social discourse in Israel. If you like what we do, please consider giving to our Patreon campaign. You'll find a link on the Tel Aviv Review website and in the show summary on your podcast app. I'm your host, Gilad Halpern.
And I'm your co-hostess, Dalia Shenlin. Our guest today is Sfard. He is a leading human rights lawyer who has acted as the main counsel for Yesh Din, Breaking the Silence, Peace Now, and on behalf of Palestinian communities, including Bil'in and others. Basically, he's one of Israel's leading human rights lawyers, and he likes to say he is a human rights lawyer and an optimist. We will be talking about his new book, The Wall and the Gate, published by Metropolitan Books in 2018, and we'll be asking a question that human rights lawyers in Israel and Palestine have been asking yourselves. Michael, I know from your book, which is what you chronicle throughout the book, and that is legal activism an effective way to oppose occupation, or could it ironically actually strengthen the policies of the government? Michael Sfard, welcome to the show.
Thank you for having me.
I want to start with proper disclosure. As a public opinion researcher and a strategic advisor, I've worked pretty extensively on these issues, including with some of your clients, Michael, including Yesh Din. But until I began learning about this world myself, I don't think I would have realized that human rights lawyers and human rights activists might actually fear that their work in a way can be seen or criticized by themselves as supporting occupation policies. I want you to help explain this problem that informs the inquiry of your book.
Right. I don't think it's unique to the struggle against the occupation. I think human rights activists and legal human rights activists have been asking themselves these kind of questions. I call them the existential questions of whether their work is helpful. Does it contribute to ending the evil regimes or the violations that they oppose so much? Or are they naive collaborators of the system? And the reason that we are asking ourselves these questions is that litigation has several types of effects on society. The short term and the most obvious one is the question of whether a case was won or defeated, whether a remedy was secured for the client or not. But regardless of whether a case can be labeled as a victory or a defeat, it has sometimes, and many times it does, long-term effects on public perception, on how people see the issue at stake in that case, and how the policy that is at the basis of the incident that was litigated has been changed or not changed, or maybe perpetuated, crystallized through that litigation. And so the question of victory and defeat is one question, but the question of success and failure, which are much more long-term, much more sociological questions, keep on creeping into, the arithmetics, the balance that we try to calculate in our work. And so a big victory in court can result in a huge backlash that eventually would achieve the opposite of what one wanted. So if we'll take, for example, I will not give an example from the occupation. I'll give an example from internal Israeli issues. The most famous victory when it comes to the equality of Israeli-Palestinian citizens, Israeli Arabs, is the case that dealt with the right of Palestinian residents to buy an apartment in a small Galil community, Jewish community. And the case was won back in the beginning of the second millennium. Aaron Barak gave a wonderful dissertation on the liberal values of equality and how Israeli Arabs should never be discriminated against.
Yeah, we're just to clarify, we're talking about former Chief Justice Aaron Barak, who is a major figure in your book as well.
That's right. Well, two figures. There's Aaron Barak of the Green Line and there's Aaron Barak of the West Bank.
Exactly.
Almost like a double personality, as you describe it.
Absolutely. A fascinating person. One of the most fascinating people I ever came across in Israel. In any event, that case at first seemed like not just a victory, but also a success. Our own Brown versus Board of Education, some labeled it. And a few years passed, and the Knesset has legislated the law that allows small communities in the Negev and the Galilee to screen families who want to join the communities and deny them for being unfit culturally or socially. Of course, being unfit culturally or socially is a euphemism for being Arabs or being single mothers or being Mizrahi or any other type that is not the hegemony. So when you ask ourselves, I mean, if I was the lawyer, I wasn't the lawyer that argued that case. It was the magnificent Dan Yakir and Netaziv. But if I were there, I were them, and I have my own cases like that. Sleepless nights asking myself, so did I do good or bad? I know that my intentions were very good. I know that. That's not a question. So there's no criminal intent here, right? But have I contributed more than I've allowed things to deteriorate?
Can we ask you to give an example from the occupation, actually, since your book really is much more about those policies? Let's talk about the one that you opened the book with, actually, in the introduction, the Tzufin Gate. Why is the fight for a gate in the wall, the security barrier, or as Israel calls it, the security barrier, other people call it a separation barrier, why was the victory of achieving a gate that allows Palestinians to cross that wall maybe emblematic of both, a victory, but also possibly something that threatens to support the larger policy?
The story of the separation barrier, and I know there are many other titles to that enterprise, the separation wall, the apartheid wall, the security barrier, etc. Each name has its own political interpretation, but I'll call it the barrier. I think it's the most neutral one. The separation barrier is an illegal enterprise which was designed to invade the West Bank rather than go on the Green Line, on the internationally acknowledged border of the Israeli sovereignty. And by invading the West Bank, it became a daylight robbery of lands. And it did so not only through a physical barrier, but also through legal means which screened Palestinians and walled them off while allowing Israelis and tourists to cross freely into the seam zone, the area between the fence and the Green Line. So the human rights approach to this enterprise was that this is a violation of international law, probably a war crime, a denial of property rights, and confiscation, on de facto confiscation of hundreds of thousands of dunams. So installing a gate, as the story that gave lend the name to my book, was a story in which I went to communities and who were suffering gravely from the grab of their lands and suffered from a huge decrease in their annual livelihood because of that, because these are agricultural communities who are based on cultivation of their lands. And after I very enthusiastically told them, look, we can take this to court and demand that the route is changed and demolish the current route because it's illegal, because of this and that. And I had all kinds of arguments. I was very enthusiastic, very young. And then the heads of the villages looked at each other and said, well, Mr. Sfard, do you think you can get them to install a gate? Because if they have a gate, and if we have a gate, we can cross during the harvest season and maybe we can harvest our trees. And for me, that placed me in the most terrible location because I knew that the army would be very happy to get from me, to have me be the middleman, the guy that allows them to understand what is more needed in order to manage this wall better, this barrier better. And I knew that they will get their gate because the army was under huge pressure by the international community, a mounting pressure because the construction of the gate was a photojournalistic disaster. So
of the barrier.
Of the barrier, yes. So for me, it was a collision of two objectives that I had. One is to secure a remedy for my clients. These are living flesh and blood people who need access to their lands in order to secure their livelihood. On the other hand, I'm not just a lawyer representing clients, I'm also a human rights lawyer, or a cause lawyer, and I want to advance a cause, and the cause is to outlaw this wall, and installing the gate would perpetuate.
So maybe the system is more sophisticated than you in having pushed you to that corner, to these dilemmas that are always on your mind as you write in the book. And on the other hand, the fact that Israel has allowed this controlled, democratic room for maneuver for people like you to operate and others is the root cause why the occupation has lasted for so long. Do you think it's some sort of premeditated ruse, or is it just, the way it is?
The system is extremely wicked, very big, very strong, and can adapt. And the movement that fights to end the occupation have always a very small window of opportunities of innovation until the system will adapt and start exploiting us. At first, they are dumbstruck. We started the campaign of litigation against the outposts. The government didn't know what to do.
Against settlement outposts.
Against settlement outposts. Against unauthorized settlements. All settlements are equally illegal, but there are those who are even more
unequal than others.
Some are more,
more unequally illegal than others. Let's get it right.
That's the animal farm, right? Yeah. But at first, they didn't know what to do. For the first time, they were in a position which we cornered them into. Then they had to decide whether they're with the thieves or with the police. And they had to account for what they say, because they have always, since the mid-90s when the outpost phenomena began, settlement outpost phenomena began, Israeli government was always providing all kinds of assurances to other governments and, in diplomatic channels and even in the media that, we will evacuate the outpost. But it never had to account for its promises. In the Israeli court, it has to account. And so we had this window of opportunity in which we could actually do something about Migron and Amona and the Ulpana and so on and so forth. But eventually, they got to their senses. They have more energy, more resources, more power, more drive, and they have no red lines. So they legislated the confiscation law, known as the regularization law, and they started retroactively koshering outposts. And that, again, begs the question. Our litigation, was it worthwhile? Did it do more good than harm? And that's a question that I try to deal with in my book.
You also try to cut through some of the incredible complexities of the legal situation in the occupied territories. And I want to see if we can try to make sense of them, because really we have three legal systems. We have Israeli civil law, well, maybe four. Israeli civil law in general. We have military law, which governs the territories. We have a special form of Israeli civil law that governs the settlements. And we have international law. How does the Israeli government make sense of all these? And then, if I can just add on to that complex question, where's the courts in all this? You explain how sometimes the courts sort of uphold the role of international law, while sometimes saying they don't apply, and then sometimes saying they apply, but they have to be applied in ways that are counter to the intention of those laws. Can you help us cut through this?
The law that is being applied to the West Bank and in the past in Gaza Strip is the mirror of the archaeology of rulers of that territory. So you have every ruler came with its own laws and changed the laws in force, but some remained in force and some the ruler changed. So we have Ottoman Turkish law. We have on top of this British mandatory law, and on top of this Jordanian law, and on top of this military ordinances and orders, and then on top of this Israeli administrative and constitutional law, and on top of all of this, international laws of occupation. And so this is a very complex system of different layers, legal layers. And the Israeli court is changing, okay? So what I'm going to say now is true for the last 50 years, but I'm not sure it will be true. I don't know, when are you airing this program? No, I'm kidding. But we're seeing a drastic change in recent years because of the composition of the court that is changing and the approach of the courts. But until recently, it was a very clear and unified opinion of the Israeli Supreme Court that international laws of war, what is also called international humanitarian law, is the constitution of the occupation or of the administration of the held territories, okay? Israel does not concede that the West Bank and Gaza and East Jerusalem and the Golan Heights are occupied territories in the legal sense. So it calls them administered lands or held lands.
Or disputed lands.
Disputed lands, yes, right. But the legal framework, the normative framework that applies is international humanitarian law. At the same time, the Israeli court has carved exceptions to the application of international law. So, for example, settlements, the question of settlements, which is it legal or not, this question is probably the most simple question to answer in any system of law. There is a complete, extremely rare consensus that, even in natural sciences, you can find such consensuses, that settlements are illegal, that transfer of civilians from the occupying power to the occupied territory is illegal. So the Israeli court said, well, there is an illegal answer to the question of whether the settlements are legal or not. But I think it's non-justiciable. I think that because the question of the future of the occupied territories is the major question that divides the Israeli public, it is not for the court to make such a fateful decision. It is for the politics to make it, for the democracy. By saying that, the court also said that only Israelis would participate in the decision-making about the future of the occupied territories and not the millions who are colonized. So you have exceptions to the application of international law, and you have many cases in which the Israeli Supreme Court has applied international law, but in such an extreme and sometimes even bizarre interpretation of what international law says that it was not accepted by any scholar and it was criticized heavily. When it comes to questions of deportation of Palestinians, I have a chapter in the book that deals with the practice that was used since the beginning of the occupation and until early 90s of deporting.
Oh, we're going to talk about that.
Okay. So there's also an unequivocal prohibition on deportation, and the Israeli court has made an interpretation that is really bizarre and got a lot of criticism.
Before we get to that, let me just ask you a question about a quote in your book that caught my eye that I thought was really enlightening. And you write, and I quote, "Human rights attorneys are both activists and lawyers. They are committed to both the ethics of human rights and the ethics of the legal profession." Now, on the face of it, it sounds almost self-evident, right? Because both lawyers and human activists are committed to justice and the promotion of justice. But can you talk about how these can clash sometimes? And, what about the relationship between those two realms of ethics differentiate you as a human rights lawyer from other lawyers?
Well, it seems at first, if among your clients you don't have tobacco companies and gas companies and huge social media conglomerates,
and George Soros.
Can we add Big Pharma?
No.
Big Pharma. I mean, there's not enough time in the world
talk about all the evil
to list all of them. Yes.
Right.
Yeah.
But I'll use it in the other way. If on your client list there are only human rights victims, human rights abuse victims, people who were abused, it seems like their interest and the general interests of promoting human rights converge, right? No. Well, not always. Not always. I'll give you an example. Let's call it a theoretical example, okay? Let's assume that I'm a lawyer and I represent Palestinian who has land and settlers invaded into his, let's assume it's a man, into his land.
Purely hypothetical.
Purely hypothetical.
Yeah. Never happened before.
Never happened. And they constructed, they built something, they uprooted his thing and they planted their own.
Hypothetical olive trees.
Hypothetical, yeah. And let's assume that this case is not resolved. It takes a year, 2, 3. And one day this hypothetical client comes to me and says, look, this land is all that I have. This is my inheritance to my kids. I think it will drag forever. And even if we win, it will take forever to implement the court decision. And even if we do that, I don't believe that I'll be able to get back to my land. Now the settlers offered to buy it for a lot of money. Can you please write a contract for me? All right, so I'm a lawyer. My ethics tells me I need to do everything that I can for my client. I'm also a human rights activist. In the human rights spectacles of this thing, it is clear that this guy was led into this. He's a twice victim. He's not only a victim of property grab, but he's also a victim of crushing his free will, if you will. What do you do? And I thought at first, when I became a lawyer and I knew that I wanted to do human rights, it will be so rare that my desire to promote human rights will collide with the interests of my specific client. And throughout the years, I found out that it's not that rare, that it happens more often than not.
Let's challenge this, though, some of your ideas in the book and some of your analyses from the other perspective. I think we have to. I mean, you have very, very intricate chapter on the history of the use of deportations. And I could ask the same question about a similarly in-depth chapter on the use of torture. I mean, you give very powerful human rights arguments for why these are all violations. But on the other hand, two of the major cases of deportations that you chronicle were connected to horrifying terror attacks. The famous Coastal Road attack in which 34 Israeli civilians were murdered, an attack in Hebron in which 6 Israeli civilians were murdered while praying. What do you say to Israelis who say we need these tactics to get rid of people who are either committing or inciting terrorism against civilians? Maybe we have no choice in a situation of conflict.
Just for the sake of the listeners who have not yet read the book.
Even though they will.
The two examples you gave, the people who were facing deportations were not involved in any way in those terror attacks. But let's assume they'd have, okay? I'm ready to defend the position that even the worst kind of people should not be deported, the same way that the worst kind of people should not be subject to capital punishment. There are some types of punishments and treatments that humanity has tried and should outlaw, because the way that we behave when it comes to our worst rivals and enemies sets down who we are. It's easy to be benevolent to the angels. It's when you treat humanely the worst of the worst that you are and you remain a human being that is eligible for the idea of sanctity of human life.
But I think many Israelis would say, I'd love to preserve the sanctity of my own integrity and all this, but I'd prefer to stay alive first.
Yeah, but
and they see this as a one-to-one trade-off. Is it a one-to-one trade-off?
This is what we are being sold, of course. Even in the most famous scenario that justifies torture, the ticking bomb scenario, Hollywood is very good at creating these scenarios, but reality is very bad at creating them. Not because there aren't any ticking bombs, but because there almost never a case where you know for sure that not only there is a ticking bomb, but this guy that is in your hands now knows where the ticking bomb is. This is a very theoretical scenario that has never been recorded, ever. And so creating a whole exception to the most important prohibition that cherishes the most fundamental protection on human beings, the protection from torture, on the basis of a very theoretical scenario that has never happened, is extremely dangerous. And if you want to ask the question of what, again, if we'll try to find what is beneficial to us, then the danger that some person would lose their life because we are not allowing torture is tenfold smaller than the danger that many, many people will be subjected for torture and without any reason.
It seems to me like we're having this discussion in some sort of vacuum, right? Without looking at the perhaps international equivalents. And also, what the court is subject to, I'm assuming by some scholars and other instances, is to some sort of judicial review, right? You said that earlier that the High Court picks and chooses according to the law, the type of legal system that fits the political purpose or perhaps conferring the purpose to another body. But how come we're having this sort of, internal moral debate here, whether it's justified or not justified, whether we are human beings or not human beings, whether we are a self-respecting democratic society? So my question is, why is there so much room for interpretation when it comes to international law? Why isn't there like one big body that comes and says, as actually you do in many instances in your book, there are repeated violations of very clear clauses in international law, something has to be done about it. Where is that voice other than Michael Sfard?
Although Michael also said there was a total consensus about the illegality of settlements, for example.
There is complete consensus in most of the issues that are raised in the book. Torture is the number one total prohibition in international law. There is no exception to the prohibition on torture. There is no exception to the prohibition on transfer of civilians from occupying power to an occupied territory. There is no exception to the prohibition on deportation of people from their homeland. You can incarcerate them for the rest of their lives, but they're entitled to be incarcerated or detained or arrested in their homeland.
And what about assassinations, which you also deal with?
And assassinations, it's a more complex issue. But assassination of civilians who are not, at the time of their targeting, actively involved in hostilities is illegal.
If all this is blatantly illegal,
maybe your question, Gilad, really is about enforcement. Maybe
exactly. So that's what I wanted to get. Look, let's go from the upper floor of international to domestic law, okay? Do those who are fluent, who have connections, who have political power and a lot of money, are subjected to the same enforcement as those who have nothing, who are not connected, who have no political backing?
Nowhere in the world.
Nowhere in the world. International law is not different. Of those who have political power.
Yeah.
And Israel is one of the most powerful political entities in the world today. For many reasons. Because of its allies, and primarily the United States, but also Western Europe, because of its history and because of what the world thinks rightly that it owes the Jewish people, because of its military power and because of its economic power. Israel is a very powerful state. And so enforcement on that state lacks extremely. And we see that with veto power being issued again and again in the Security Council when it comes to resolutions against Israel. We see it all the time when it comes to how the international community behaves towards Israel, even when it is clear that Israel is in violation of its decisions. So condemnation repeats a condemnation, but there is not much other things that are done. Look at how the European Union was struggling with the simple, small question of labeling of produce from settlements, which is, it's not even saying this illegal exploitation of the economy of the occupied land will not reach our shores. Not even that, just labeling.
So the commitment of the High Court of Justice here in Israel to democracy and all these lofty ideas of human rights, international law and all that, it's a charade. The minute that the international support for Israel collapses, whether that ever happens or not, it will be caught with its pants down?
These are two different entities. The Israeli Supreme Court has, since it was created, was devoted, at least in its declarations, to the basic liberal values of human rights. And it applied them to some extent inside Israel. And we cannot take that away from the Israeli Supreme Court.
And in the territories?
No. In the territories, from the outset, it was clear that this is not a democracy. And the Israeli Supreme Court not only allowed it to violate the very basic freedoms that it elevated to a constitutional level inside Israel, like freedom of speech and things like that. It allowed to violate all of them in the West Bank, but it also allowed to make changes in the occupied territory that are long-term, that perpetuate the occupation, that shifts it from a temporary, unwanted reality into something that is more like annexation and, we'll have to say the word apartheid.
But so why is there a perception of the Supreme Court in Israel that it's somehow on the side of the left and helping these liberal human rights, troublemakers? Why that dissonance when you're saying actually what the Supreme Court has done has helped to perpetuate the policies of military occupation?
Why is the UN the organ that is the primary enabler of the establishment of the State of Israel considered anti-Israeli? The Israeli Supreme Court, being a leftist, pro-Palestinian court, is the biggest and most successful lie in the last 50 years. I'm not saying that the Israeli court is a pro-settler, right-wing court. I think the court would be judged in history as a court that allowed and made the occupation stable, and it allowed the settlement enterprise to flourish.
And maybe we should also point out that both judges on the court and other leaders of civilian institutions in Israeli life grew out of the military system and the military justice system, where were responsible for developing it, and then moved into civilian life. So there's quite an overlap of the same people.
Right. If I had to say what is the party, there was once a saying about the court. One of the manifestations of that lie is that the court is a branch of Meretz. In the 80s, that it was a famous slogan by the right. I'm sure it's not a branch of Meretz. It's not a branch of the Likud either. It is a branch of the security establishment. The one parameter that prophesies better than anything else what would be an outcome of a case is what the security establishment think of that case.
We have to wrap up, but I want to ask one last question that diverges a little bit from all these troubling issues. Much of your book is actually about sort of pioneers in the human rights legal world in Israel. You really chronicle the lives of people like Leah Tzemel, Felicia Langer, Avigdor Feldman. Can you characterize them? Do they have something in common as people? And are these your personal inspiration? Are these people who inspired you to go into human rights law?
Absolutely. I think these are people that worked in a setting, in a theater that is very different than today's. In a way, it was more difficult because there was no NGO world like we have today in Israel. And they were really, really alone, these lone cowboys.
And girls.
And cowgirls, right.
Yeah.
Hello.
First of all, actually, one thing that was so fascinating to see in my research was how women were the first. They were the real pioneers. I mean, Avigdor Feldman came later, but the first ones were two Polish-speaking Jewish women, Felicia Langer and Leah Tzemel, and their connection with the Palestinian society was through their socialist, some communist affiliations. And only later came the men. So, yeah, it's a very interesting fact about that.
I would ask you to explain that, but I don't want to put you in the position of mansplaining. So,
No, but it's really fascinating to see how they were the ones who were walking in the streets of Ramallah and Jenin and Hebron when no Israeli man would go by himself there. And later on, Tamar Peleg, there are so many women in this story of human rights activists, legal activists throughout the last 50 years. Human rights law in general is a feminist, a more female-dominated field. But you asked me what combines them all. I think that the notion of fighting evil in the very fundamental sense. I mean, these are I know most of them personally. And these are people that when you ask what makes them tick is anger in the face of injustice. And that anger is being translated into words and briefs and to moral concepts. And each one is different, very different. I mean, Feldman is a completely different personality than Felicia Langer or Leah Tzemel or Danya Kir and the others. Should also mention Elias Khoury, the lawyer, and Raja Shehadeh, the Palestinian today is also a poet and a famous writer. These were all people that used their profession. None of them went to do law because that's what they thought they would do. I mean, Avigdor Feldman did family law in his first year. Felicia Langer was admitted to a regular law firm doing criminal defense and so on.
But do you see a line connecting you to them? Is, I don't know, anger what makes Michael Sfard tick as well?
Yes, very much. I mean, it's a way to translate the anger into something productive. And it's also, I think, many of them, not all of them, but some of them, come from Holocaust surviving families. Felicia Langer passed the Holocaust herself. Avigdor Feldman's parents were in death camps. I'm third generation to Holocaust survivors. And I think there's something that, not all, of course, there are others but lessons learned from Jewish persecution is definitely something that at least some of the Jewish lawyers characters in the book had was a pretty big weight that drove them to do what they did.
Well, I think I'll just sum up by saying your book is a chronicle of all these things, but specifically I think what stands out is that there are a number of successes, a lot of failures, and a lot of dilemmas. And so the failures made me think these are people of incredible tenacity. Would you agree with that characterization?
Yeah, I just want to say the game is not over yet.
Oh, no.
Right?
Yeah, so exactly. Yeah,
and we'll probably have this conversation another 10 years.
That's the answer, yeah.
Okay, that's Michael Sfard talking about his new book, The Wall and the Gate, about the legal structures of occupation and the decades of legal battles against it. Thank you for being on the show.
Thank you very much for having me.
And now a request. Many or most of you listen to us on the Apple Podcasts app, and we have a special request for you. Please consider writing us a review. Just launch the app, select our podcast in the library section, scroll down to ratings and review, and press write a review, and then write one. You can also support us by going to our website, that's tlv1.fm/Tel Aviv Review, and subscribing on our Patreon campaign. We've got gifts for you and other perks as well. Check out our archive with almost 450 interviews. If you like what we do here, you can also like us on Facebook. Our page is called the Tel Aviv Review Podcast Ideas from Israel. And last but not least, follow me and Dalia on Twitter. Join us again next week for another edition of the Tel Aviv Review. And until then, goodbye.